I hope you're doing well and ready for the snow. We made it to Friday for OJ. We're going over jury instructions, guys. You know what that means. Jury's going to deliberate soon. I can't imagine that day the jury walks into the jury room, the trial's over, and they're like, guys, I just want to go home. Guys, we all just want to go home. Just tell me what to say. I'll say whatever you guys want me to say. I don't care. I just want to go home. That's why he was acquitted. The jury just wanted to go home. All right. Let's go. Speed. Playback speed. No, we don't do normal on this channel. There we go. Loopy thing on and go.
Is significant evidence of guilt. I'm inclined to do, so I'm going to decline
Hold on.
instruction to give the standard 2.51. All right, D26.
D26, Your Honor, again, we're getting into this issue of defining reasonable doubt, but now we are going into specifically circumstantial evidence.
Hate YouTube. Hate it.
With all due respect to Dean Uelmen, going back to a 1931 case predating the Kelberg instructions, I think suggests that this is probably not an instruction of law that has been well received in recent time. 2.01, 2.02 are time-tested, proper statements. In fact, this statement, if the court looks to the second to the last line, but they must exclude to a moral certainty every other theory. Those words, moral certainty, seem to have created a lot of activity in the United States Supreme Court and in the Kelberg Committee and in Sacramento with respect to 1096 and 2.90. I submit, Your Honor, that this is clearly not an appropriate statement of law. 2.01 is and is the instruction that should be given.
Your Honor, the fact that we have venerable citations dating back 60 years should not detract from their weight, but should add to their weight. The core principles that in a circumstantial case, the prosecution must exclude every reasonable possibility that the evidence must be inconsistent with any reasonable theory other than guilt is such a core and important principle in this case that we do not believe it can be possibly overemphasized, and that this instruction, based on McQueen, is an appropriate addition to the standard Kelberg instruction.
All right. I don't believe the terminology here is sufficiently modern, and I'm going to decline to give it. I think it's adequately covered by 2.01. All right, D27.
Your Honor, again, basically the same arguments that I made to D26, but even the last sentence is even more inappropriate. All doubt should be resolved in the defendant's favor. 2.90 says one does not look to imaginary or possible doubt. One looks to reasonable doubt. So whatever was the thinking in 1947 in the Denton case, I think, as the court has indicated, modern language and modern interpretations of the due process clause and reasonable doubt dictate that this instruction be denied.
We'll submit it on the same argument as previously, Your Honor. We're moving up, though, from 1931 to 1947.
See, we're about to leap to 1986.
I think that's 68, though, actually, Your Honor. It's going to turn out to be 68.
Yes, it is. 257 Calap second. All right, I'm going to decline D27. D28.
D28, Your Honor, 2.90, the Freeman argument, everything I've said about the need to stay with 2.90 and what 1096A says. And again, 1968 authority, given what has happened with Freeman and with Sandoval versus California, Victor versus Nebraska, this is terrible. First of all, I just happen to notice in the third line, it's talking about in the indictment. I don't think this case is being prosecuted under an indictment. Again, what was going on in 1968, I don't think is terribly relevant to the appropriate language that should be given a jury. 2.90 is the appropriate language submitted.
We'll certainly agree to the substitution of information for indictment in the third line, Your Honor, but we believe it is important that the jury be told that the reasonable doubt standard applies to every fact or element necessary for a conviction.
All right, I think that that's already made clear by the standard jury instructions dealing with reasonable doubt and the use of circumstantial evidence, so I'll decline D28.
They're practicing to be Catholic. Stand up, sit down. Stand up, sit down. Stand up, sit down. If they start kneeling, though, we're in trouble.
D29.
We're regressing, Your Honor.
Yes,
moved
we
back
are.
48 years. We're now in 1920 with the Bickerstaff opinion. Your Honor, again, 2.90 tells the jury what is the standard, what is the test, and I'll submit the matter on the previous arguments.
I don't believe 2.90 addresses the particular point emphasized in this instruction, that the jury cannot convict based on mere suspicion, and that even if they have a suspicion, that should not in any way dissuade them from returning a verdict of not guilty if they have a reasonable doubt. And that's a distinction that should be made very clear to the jury in the instructions, that a suspicion should not in any way dissuade them from a finding of a reasonable doubt.
All right, this is adequately covered in 290. I'll decline D29. D30.
D30, again, Your Honor, 2.90 Freeman. You'll notice that the instruction ends with to a moral certainty. Again, the archaic language that has been knocked out, and I just submitted on the same arguments.
Submitted.
All right. D30 be declined. D31.
I believe, Your Honor, the court has rejected this one and offered 4.50, which I have given to the court in the form I understood the court wanted to modify.
That's correct.
And similarly, D32.
That's correct. All right, D33.
Your Honor, somewhat similar to the proposed special instruction dealing with absence of motive, now we are talking in terms of evidence of demeanor. First of all, of course, this is trying to single out a class of evidence for the jury's consideration, which the people submit is not appropriate in a jury instruction. But what's to me interesting is the defendant has offered evidence that his demeanor was inconsistent with the demeanor of one who was planning or had committed the brutal murders in this case. It'll be for the jury to decide what is the expected demeanor of a murder. I don't believe any expert testimony was offered on that subject, at least as I understand it.
Somebody tried, though.
I hope you're not looking at me and suggesting that I did. Did I?
No, you didn't, but somebody on that side of the table tried.
I can't be held accountable for the sins of all of my colleagues. The other thing is, the second sentence goes on, such
Yes,
evidence
you
alone
can.
may require, leaving out, of course, even the necessary phrasing, if believed, since clearly this is the one-sided evidence of the defense. It is argumentative. It's a matter for argument by counsel. This instruction should be rejected.
We don't object to the insertion of such evidence alone, if believed, may require the defendant's acquittal. This, again, goes back to the bedrock principle, Your Honor, that the defendant's theory of the case which the evidence justifies, no matter how weak or unconvincing the court may find that evidence, we are entitled to an instruction to the jury on our theory of the case. And the defendant's theory of the case does include demeanor evidence as a very important element of reasonable doubt, that if the demeanor of the defendant immediately before and immediately after the alleged commission of this crime is inconsistent with the demeanor of one who had committed a crime such as that in this case, that alone can give rise to a reasonable doubt. There is nothing in any of the CalJIC instructions that covers that point, that addresses the significance of demeanor evidence. And since demeanor evidence is such a significant part of the defendant's theory of the case, we believe we're entitled to have the jury given this instruction, which is an accurate statement of how they should assess that evidence.
All right, I'll think about this one. All right, D34.
No, I think the same arguments, in some degree, dealing with 2.90 apply here. Again, you will notice moral certainty language appearing in line 2, appearing in the second to the last line of the proposed instruction. 8.20 spells out in time-tested language what is the necessity to find a first-degree murder based upon willful, premeditated, and deliberate murder. And that there is no basis to submit, again, language which is found to be dangerous from Freeman and so forth, and which is in fact not necessary given 2.90 and 8.20 submitted, Your Honor.
We'll withdraw the reference to moral certainty on line 4 and line 6 of this instruction. The remainder of the instruction is approved by People v. Conley, and we believe is significant in the context of a case where the only theory justifying a first-degree verdict here is to find that the defendant did carefully weigh the course of his action and weighed the considerations for and against it. This language is not included in CalJIC 820, and in the circumstances of this case, it is an accurate description of the law and an appropriate instruction to give the jury.
I got to just point out 8.70 which is in our proposed packet, informs the jury about their duty to determine the degree of murder. 8.71 tells the jury if they are not convinced beyond a reasonable doubt, if they have a reasonable doubt as to the degree, they must give the defendant the benefit of the reasonable doubt and find it to be murder in the second degree. So that is covered by additional instruction.
All right, I'm going to decline the special instruction. It is adequately covered in the pattern instructions from CalJ. D35.
Your Honor, again, we're back to the same arguments, 290, Freeman, and so forth. There's nothing new to add.
We'll again withdraw the reference to moral certainty in line 7. But again, this addresses an aspect of reasonable doubt that is not adequately addressed in the CalJIC instruction, especially in the context of a case where the jury might be inclined to speculate about the failure to prove the identity of the person who actually committed the crime. We do have a situation in this case where the court's rulings have precluded the defense from offering evidence with respect to other possibilities. That simply leaves the jury free to speculate and wonder and to hold against the defendant the failure to offer evidence of who actually committed this crime. Under these circumstances, we believe it is urgently necessary for the court to say to the jury what the law actually is, that the defendant does not have to prove himself innocent, he does not have to prove that another person committed the crime, and they should not hold it against the defendant in assessing reasonable doubt that evidence was not brought in as to who actually committed these crimes.
May I briefly respond?
Briefly.
Your Honor, we submitted proposed jury instruction number 2, which I inferentially gather was rejected, dealing with the burden on the prosecution to prove not only the elements of the offense, but the identity of the defendant as the perpetrator. The defendant has the benefit of 4.50, which the court has modified and is going to give. The jury is going to be fully apprised. There's not going to be the slightest doubt, imaginary or possible, for this group of 12 people, that if in fact we cannot prove that Mr. Simpson is guilty as the perpetrator by evidence beyond a reasonable doubt, that he gets a verdict of not guilty. That's clear. This instruction adds nothing to the other things. I would resubmit it. The court really never ruled on people's proposed number 2 that the court give that. But 290 and all the other instructions that I've indicated fully cover this, and this becomes fully redundant and unnecessary.
Your Honor, this simply ignores the fact that the absence of this evidence can work against the defendant in terms of the jury's assessment of whether they have a reasonable doubt. It's not enough to just tell them you have to find the defendant guilty beyond a reasonable doubt. It's also appropriate to tell them that finding a reasonable doubt is not precluded by the failure to produce evidence of who actually committed the crime.
All right. Court will give court special instruction that will read as follows. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was a perpetrator of any such crimes. The defendant is not required to prove himself innocent or to prove that another person committed the crimes charged.
Does the court wish us to prepare that instruction?
Please.
Did the court write out its...
Yes.
Could I get that at the break?
Yes.
Thank you.
All right, D36.
And I assume the court is rejecting D35.
Actually, it's a combination of special instruction 2 by the people and D35 submitted by the defense. D36. Sounds like a Martin guitar catalog.
I'm sorry, Your Honor?
Never mind.
The citation, perhaps, says all I need to argue on this one. I'll submit it.
This simply expands on what the court has already indicated it would give, and we're all the way back to 1873.
In Illinois, apparently. I wonder if Abraham Lincoln had something to do with drafting.
I don't think so.
I really
It's about 8 years too late.
Well, no, but he may have drafted it at the trial level. It took a long time to get into the appellate court.
No, I don't think it took that long back then. All right, I think this is sufficiently covered by the other instructions. D37.
Your Honor, I think basically the same applies. The D37 court has worked out a compromise, and again, for all the reasons previously submitted, would ask the court to reject this and give the instructions that the court has already indicated at this point in order.
I think it's appropriate in a case in which the defense essentially is that the defendant is not the person who committed the crime, that identity is an element of the crime, that, although not an element of the crime, but the fact that the people must prove beyond a reasonable doubt. And a reasonable doubt simply as to identity is sufficient to justify the fit.
All right, I think this is adequately covered by the other instructions, and I'll decline D37. D38.
Your Honor, this instruction is properly and accurately covered in 17.40, which gives the jury an instruction of law dealing with their responsibilities. This is made clear to them, and that in essence, this is the Allen instruction, if you will. It's from the defense perspective, trying to impress upon the jury that you can hold out, because as everybody understands, we need 12, they need 1. And so it is not, number one, appropriate to try and focus on things which would suggest to jurors that they should hold out. Number two, 1740 tells the jury how they should approach their responsibilities. And number three, even if we were in federal court where an Allen instruction might be available, such an instruction such as this would come at the end of the case, not as one is about to instruct the jury, which is to begin deliberations. It should not be given. We should stay with the pattern instruction 17.40 submitted.
We believe this is an appropriate instruction, that it is supported by People versus Wade. This is not an invitation to jurors to hold out or be unreasonable in the deliberative process, but to inform them of their responsibility to individually reach a verdict, and if they haven't a reasonable doubt, not to be influenced to vote in favor of conviction simply for the mere purpose of getting a verdict. And we believe in the context of a trial of this duration, of the amount of effort and expense that has gone into it, there may be a tendency on the part of jurors to think that the most important thing is for them to get a verdict, even if they do entertain a reasonable doubt.
Okay, okay. I have a feeling that just typing a joke isn't going to make Josh laugh, which we don't want to do because it will hurt him. So why would we want to make Josh laugh? I don't know. But what is Brown and rhymes with Snoop? I'll give you a second. Dr. Dre?
So we believe in the circumstances of this case, this is a very appropriate instruction.
All right. I think that A1, the pattern instructions, do in fact cover this adequately, and I think this will be the subject of strong argument by counsel on both sides. All right. Any other instructions that need to be contemplated at this point?
I believe we have the shift instruction.
Yes.
We also had, I'm trying to remember where the farmer case fit in as to which instruction.
All right. Let's go to the ship instruction. If I can find my copy here.
He's one of my top faves. People.
All right, Mr.
Just
Uelmen.
a general
Yes, Your
as a
Honor.
person.
Our problem with this instruction is that there are really three alternatives with respect to the shift testimony, and this instruction only lays out two of them. The third alternative, our position is that this statement was never made. And the instruction assumes that the jury will find that the statement was made, and gives them two alternatives in terms of how they might construe that statement, and then the evidentiary effect they should give to it. So we believe the instruction should also include, if you find the statement never occurred, of course you will disregard it. And when it refers to the statement, refer to it as an alleged statement.
Your Honor, I did not have the benefit of hearing in person the arguments or the ultimate testimony of Mr. Schiff, but I have reviewed the appropriate citations in the transcript. I notice on page 12,686, the court ruled on the admissibility of that testimony without a limitation. The court said the statement regarding the dreams about killing will be admitted. The actual testimony that was heard by the jury is on page 12,779, and the statement on line 22, the answer that is, he kind of jokingly just said, you know, to be honest, Schiff, that's what he called me, Schiff. He said, I've had some dreams of killing her. It seems to me, Your Honor, that this instruction is dictating to the jury how they should assess that evidence, when in fact it is for the jury to assess that evidence. In essence, it seems to me, with all due respect to the court, that the court is revisiting whether the court properly ruled on admitting the evidence in the first place. But that's a little late, no offense to the court. The issue is the evidence was received. In the event Mr. Simpson is convicted, I'm sure it will be an issue on appeal. But as far as trying to single out a particular piece of evidence and say to the court that, say to the jury, excuse me, that this is specifically how you must evaluate this. If it's this, you got to go this way. If it's that, you can go the other way. This is argument for the jury to hear from counsel, not in the form of a jury instruction. And I say that with all due respect. The court has had an incredible number of decisions to make, and they are difficult decisions. And there's nobody in the world who can make the correct decision every time. But as judges and lawyers know, good judges, as yourself, make decisions and move on. They don't revisit them. If they get overturned, they get overturned. And it happens to all lawyers. We've all had cases come back to be retried, and judges have had cases come back to be retried. But to use a jury instruction for this narrow focus of evidence rather than to allow argument by counsel, I think would be a mistake.
But don't you think that if I perceive a significant problem, and if I can avoid having this case coming back by giving an appropriate instruction, better late than never?
No, I don't think so, Your Honor, because
ship happens?
To be honest with you, I think if the court really felt the court made a mistake, the court would entertain a motion to strike the testimony and instruct the jury to disregard it. And that really, in my judgment, is what the court would have to do to deal with this. Otherwise, it's in without limitation. It is for the jury to evaluate based upon the argument of counsel. I'll submit that.
Well, Your Honor, at this time, we would make a motion to strike that testimony. Alternatively, if the testimony is not going to be struck, we believe a limiting instruction is highly appropriate. And an argument that because the court didn't give a limiting instruction when evidence was admitted, it is somehow precluded from giving a limiting instruction at the close of the evidence finds no support in the law whatsoever. We believe that it's the court's obligation, if there is really concern that evidence will be misused, that it will be applied by the jury in a way that is contrary to the court's intentions when the evidence was admitted, the appropriate remedy is to give a limiting instruction.
All right, the court will instruct the jury as follows, and this will follow after the 220 series of instructions. Witness Ronald Shipp testified to a statement alleged to have been made by the defendant concerning dreams. If you find, you must first determine whether such statement was made by the defendant. If you find that the statement was not made by the defendant, you shall disregard the statement. If you find the statement referred to subconscious thoughts while asleep, you are to disregard the statement. If you find that the statement referred to an expression of a desire or expectation, you may give such statement the weight to which you feel it is entitled. Evidence of oral statements made by a defendant should be viewed with caution. That will be the court's instruction.
Your Honor, do you wish us to prepare it, and if so, can I obtain the instruction as written by the court?
Yes. Since you have the computer program.
I'm sorry, Your Honor.
Never mind. All right.
Motion to strike is denied.
Denied. I think given the way it's interpreted, since it was an ambiguous statement, it could be taken either as an expression of what happens while one is asleep or as an expression of desire or expectation. It could be interpreted either way.
Your Honor, there are a few additional instructions.
Which are?
I offered 2.13 modified. These have been given. This is in this latest packet that I brought down that had the court's desired instruction regarding DNA evidence.
The latest package.
This afternoon that I gave you that had, I think, on the face?
Yes.
Okay. 2.13, because of the computer program, I'm told that they couldn't write the word modified after Calgic 2.13, but it is a modified. And the reason is because of Mr. Paradas' videotape, which was admitted under 1202 of the evidence code, cannot be considered for the truth of the matter asserted. And that's why this form instruction needed to be modified.
All right. Do you have that 2.13, Mr. Uelmen?
I'm trying to look at it right now.
May I give?
Please. And counsel, as soon as we finish our jury instruction conversation, I'll direct Mr. Kelberg to create the appropriate package and file that with the court by the close of business today. And then we'll take a brief recess and then launch into the exhibits.
Your Honor, for my edification, how does the court want to handle deletions and so forth in the standard instructions? Do you want us to delete them or leave them for the court to strike out in the fashion the court prefers?
Give them to me and I'll make the deletions and corrections. Except for the ones that we've already agreed that you're going to modify the...
Correct. Sure.
We have no objection to 213, Your Honor.
All
We
right.
also have one other additional matter with respect to instructions. Again, revisiting some of the shift that happened in this case. Your Honor will recall that the defense sought sanctions with respect to the withholding of the notorious page 4, the incident involving the missing page of a document with a staple hole.
All right, we have I'll call these sanction instructions.
Well, we had indicated at the time that our concern in seeking an instruction was to offset any possible argument of this issue to the jury. And rather than re-emphasize it with a jury instruction, we feel that an even more appropriate remedy would simply be to foreclose any argument that any adverse inference can be drawn against the defense as a result of that incident. And if there is an agreement that that will not be argued, an instruction would not be necessary.
I don't think that I'm adequately informed on this issue. It is not really a jury instruction issue. It is an issue in the form of a motion.
All right, here's the thing, though. During the course of our discussion about the page 4 staple incident, I did dictate, and it's in the record, the instruction that I was going to give as a curative instruction. So you're on notice as to what the court was going to say and will say. And I'm sure Mr. Byrne will find that for me in about 2 minutes.
I'll pass the wisdom on to the powers that will argue the case.
And it turned out to be such in the entire milieu of what we have here, I suspect we're not going to be arguing staple holes.
I would hope not, Your Honor. Based on what I heard yesterday about hypodermic syringes, I think I would have to agree with the court's assessment.
All right.
Your Honor, there actually are a couple more instructions.
Would you notify me, however, before the close of business today as to what your intent is so I can resurrect the language out of the transcript?
If I may I ask Mr. Hodgman, who has, I think, more direct involvement in the closing argument aspect, to speak to the appropriate people and to either directly inform the court or inform me, and I'll inform the
Fine.
court.
All right, second,
We could be notified as well.
certainly. Second sanction issue instruction has to do with the contact sheet issue.
Your Honor, we had, I believe Mr. Cochran talked to Ms. Clark yesterday or the day before about elevating the level of our relationship with each side in terms of, they are seeking...
Better late than never.
Yeah. They were seeking a sanction instruction on the Lee notes. We were seeking a sanction instruction on the contact sheets, as well as a couple of outstanding sanctions on Ms. Clark. And we had proposed just canceling all that out and moving on to closing argument. I don't know what the other side, what their response is to that.
Your Honor, I'd be glad to elevate for the public's perception of the legal profession by gladly joining in that stipulation.
All right, thank you. All right, then
Still some more, Your Honor.
More?
Just for the record. 8.31, again, in the same packet I just gave the court, but it'll be a part of the final packet that we produce. That's the alternative of second-degree murder on the implied malice theory.
Yes.
I've given the court,
And the defense objections noted.
and I've given the court what I believe is the court's requested modification to 4.50.
And let me just make sure, Mr. Uelmen, you have that 4.50 as modified by the court?
I gave it to him, but
I
here's
know,
another
I know
copy.
we did, and I'm trying to figure out how it got lost in such a small stack.
And Mr. Kelberg, as far as your timing, the close of business today is 6 o'clock.
Thank you, Your Honor. I'm not computer literate, but I'm sure we have people up there who are, can generate these things in another
Well,
class.
Judge Adler's Calchic program is rather amazing.
I'll take your word on that, Your Honor. I still have to go the old-fashioned one.
No, I mean, it has global commands. It can do all sorts of amazing.
These are meaningless concepts to me, Your Honor. I also gave Mr. Uelmen what I understood to be the suggested revision to 3.31, combining specific intent, mental state, and the requisite elements in the 2 degrees of murder. I don't know if the board had a chance to look at that. That's also part of the package I submitted.
I believe both of these revisions do accurately reflect the ruling of the court.
All right, thank you. All right, anything else?
Not on instructions, I don't believe, Your
All
Honor.
right.
The court is going to take under submission, I gather, several of these instructions.
Oh, we need to conclude our discussion on the farmer instruction. I'm sorry. That's what we needed to do.
That's 211.5, I think, on the instruction.
Right. And then Mr. Scheck was going to get me some case authority on the DNA instruction.
Yes.
So that one remains open, and there was one of the Ds that I left
D35,
out.
I think, Your Honor, is indicated.
I was going to think about it.
Your Honor, if I might, I would like to be heard.
D33.
I'm sorry, you're right. I would like to be heard, if I could, just briefly on that instruction as well.
Well, that's one I've heard the argument. I'm going to think about it. All right, let's discuss the farmer issue.
Zach, you're not wrong.
The facts in Farmer are exactly the kind of facts which lead to the 2.11.5 being informed in the language it is. In Farmer, you have multiple identifiable defendants, but they are tried separately. So the jury, in order not to be misled, and I'm afraid somebody moved the specific citation in the case dealing with 211.5, if I could have just a moment. Oh, there we go. On page 918. The defendant was the one objecting to the instruction on unjoined perpetrators. The instruction, according to the Court of Appeal, does not tell the jury it cannot consider evidence that someone else committed the crime, citing Hall. And as I recall from what I have heard in this case, based upon Hall and his progeny, the court rejected certain efforts with respect to the admissibility of third parties in this case. The Court of Appeal, not Court of Appeal, Supreme Court in Farmer goes on. It merely says the jury is not to speculate on whether someone else might or might not be prosecuted, and the word prosecuted is italicized for emphasis. And that's really what 2.11.5 is all about, that the jury not convict Mr. Simpson, or in this case Mr. Farmer, on the theory that the jury may be concerned that because they don't have this other person available, they should take it out on this individual. And that's why 2.11.5 is drafted, and drafted in the language in which it presently appears in the revision. It is not appropriate for this situation. Counsel's argument is really an argument to the jury about whether, if the jury believe there are multiple killers, that creates a basis to understand it could not be Mr. Simpson involved at all. Not a concern that he would be convicted because there is some identifiable other person who's not present in this courtroom. Submitted, Your Honor.
Well, again, Your Honor, this simply emphasizes the appropriateness of the instruction in this case. You can bet that the defense will argue that there was more than one perpetrator involved in this homicide, and that's a very relevant fact. But what the jury is not to speculate on is why such other person is not here on trial. And there is the risk that an adverse inference can be drawn against the defendant from the absence of another person on trial, and the jury should be told. You simply should not speculate about that. That is not a concern to you in this case. And in the facts of this case, that is an appropriate instruction. It is in the precise form recommended in the Farmer case and in the revision to 211.5. We believe the jury should be instructed to that effect.
All right. I find that the fact situation in this case does not lend itself to 211.5 since there's no identifiable other suspect. And also, this jury is not under any impression that there has been any other person indicted or arrested or accused of this crime. All right, we'll take a 15-minute recess, and then we'll shift into the exhibits discussion.
Your Honor, I have some exhibits which I've been notified through one of our younger lawyers, Mr. Douglas, is going to pose objections to or has posed objections to, but I'm also under instructions from the court to get this packet going. If I may be excused for maybe a half an hour I'm going to go upstairs with Mr. Yocos and Mr. Hodgman, but I've got really the best packet of materials to give the people to get everything together in the format the court wants. If I could be excused till perhaps 3:30, just to make sure everything gets rolling.
3:30.
Thank you, Your Honor.
All right, Mr. Ormond, I'm going to excuse you because the videotapes I can look at myself. All right, thank you. All right, we'll be in recess till 3:30.
Your Honor, can I get the instructions?
Yes.
Please clear the courtroom.
Mr. Douglas, previously Deputy Jex had advised me that Mr. Simpson wished to waive his presence for the exhibits discussion.
That's correct, Your
All right, and you're authorized on his behalf to waive his presence for these proceedings?
Honor. I am, Your Honor.
All right. The court will accept the waiver. All right, Mr. Darden, you're here to argue certain items of evidence.
Just a couple of items that as I understand it, the defense has lodged an objection to.
All right, which items are those, counsel?
500 and 501.
500 and 501.
I'll withdraw both of those.
All right, both 500 and 5... I'm sorry, I just lost Mrs. Robertson. All right, Mrs. All right, I'm sorry. All right, the prosecution is withdrawing both 500 and 501.
And that will be the one-page statement of Patricia Beret and,
501 is a number of photographs.
I'm sorry, not 501, Judge. I apologize. Just 500.
500.
Right.
All right, 500 is withdrawn.
Okay.
Which is a
501
statement of Patricia Beret.
Yes. Okay, 501 are the 15 photographs shown to Mr. Heidstra. He testified that he heard a metal gate slam,
Yes.
and he was confronted with several photographs of metal gates attached
In
to
the area?
homes. Yes, in the area attached to homes on the west side of Bundy and adjacent to and around 875 South Bundy. And it was his testimony that those pictures were, in fact, photos of gates at those locations. And so there was proper foundation on 501.
All right, Mr. Douglas.
Your Honor, if the court looks at page 36473 and 36474, you'll find that there was no clear acknowledgement by Mr. Heidstra authenticating the pictures. What occurred was there was an ambiguous answer given to a compound question. The question being, you see this stack of photographs, and you also see that there are numbers for the houses in the photographs as well. And the answer is, oh, sure. And I think that that is not sufficiently adequate to lay a proper foundation for the introduction of those photographs.
All right, is the matter submitted?
It is.
All right, the objection will be overruled. The photographs depict, as Mr. Darden indicated, numerous gates, metal
All right,
gates in the
guys.
area. Also,
I'll
the
be back in a little bit.
aerial photographs
Be good.
depict the same gates, only at more distant locations, I mean, from a more distant view. And I think there's an adequate foundation. It's also a minor point. Mr. Darden.
There is an objection to items 535 and 536.
All right, 535.
They're the same as 491 and 492 as well.
535 and 536, and you are correct, they are also 491 and 492.
At page 38, 346, these photographs were both shown to Detective Looper during the defense case, or these photographs rather. And Detective Looper testified. These are the wedding photos?
This is one photograph of somebody holding up the bedspread with the photograph underneath, and then the photograph turned over.
Yes, thank you. Detective Looper testified at those page numbers that he recovered that photograph from beneath the bed on June 13th. Initially, the photographs were shown to Gigi Garain, and she could not authenticate them or their location on the date of June 13th, but Detective Looper did that.
I didn't have a chance to reference Looper, but I know that Arnell Simpson was asked about him, and she could not lay a foundation. Gigi was asked about him, and she too could not lay a foundation. And I think Ms. Collins, one of the earlier witnesses for the defense, was also asked about him and could not lay a foundation. I don't have a specific recollection as to Mr. Looper.
All right, the court does recollect Detective Looper's testimony regarding the recovery of these items, so the objection will be overruled.
With regard,
Gentlemen, Your Honor, which two will come in there? For
Well, the problem is, I'm going to have to leave them both in, because different people testified to them at different points and identified them as different exhibits. So we're kind of stuck with having duplicate photos,
okay.
because they're in vastly different parts of the case.
Well, Your Honor, he was referring to 535 and 536.
That's correct.
I don't think that there's a doubt that 491 and 492 were not properly authenticated. I don't think Mr. Darden is even arguing that.
All right, do you agree with that?
Well, that's fine, Judge.
All right, the objection will be sustained then as to 491 and 492.
There is also 603 and 604. 603 is the non-disclosure agreement signed by Laura McKinney's lawyer. And 604 is the personnel complaint
right, give me
involving Roderick Hodge.
604, we withdraw our objection to.
I'm sorry?
We withdraw our objection to 604.
We're not seeking to admit 604. No authentication.
Well, then we'll seek to admit it.
Hearsay contained in it and the complaints of other persons.
All right, hold on, let's do 603 first.
Okay.
All right, 603
That's withdrawn.
withdrawn. Any comment, Mr. Douglas?
On 603,
Yes.
she was unable to authenticate it, so I think
Right.
that's proper.
All right, 603 is withdrawn. All right, 604 is the personnel complaint testified to by Roderick Hodge.
Testified there was a document he'd never seen before. No one was called to authenticate the document. It contains hearsay, the hearsay of other individuals, and there's a 352 objection.
All right, Mr. Douglas.
The significance of the document, Your Honor, as was used by the defense, was to support the position that Mr. Hodge's complaints on the occasion of his arrest, as far as certain words that were spoken by Mr. Furman in the presence of his partner, were complained to through this official document. And I thought that the information was being used by the people to suggest and to impeach Mr. Hodge by suggesting that the absence of any references to that allegation would undermine the credibility of Mr. Hodge. We think, Your Honor, that the absence of any references in that document supports our position that there was, in fact, a difficulty or a problem, or, if you will, a failure by law enforcement agencies to acknowledge certain complaints that were lodged against them. And we would like to have that document admitted so that we can argue the implications of the absence of that claim. Because certainly the document reflects the occasion of Mr. Hodge's arrest. It reflects the circumstances of his arrest. And he acknowledged that it reflected his incident. He acknowledged his having made certain claims. And we think that the absence of that particular reference is important for our theory of our defense.
All right. The court finds that there's no foundation for this. It was used as an impeachment document, but Mr. Hodge indicated he had not seen it. And it did reflect, according to Mr. Hodge, an allegation of discourtesy, which was consistent with his testimony here. So the objection will be sustained.
The objection is what?
Sustained.
Thank you.
The withdrawal is upheld, depending on how you want to look at it. All right, Mr. Zarden.
That's all I have.
All right, get rested.
Could the court entertain the exhibits that I deal with so I can get back upstairs?
Yes, please.
Your Honor, the note I have, and please correct me, Mr. Douglas, if I am acting on erroneous information. The defense is objecting to 507.
The objection is withdrawn.
Well, Your Honor, we are not offering, we're going to have a lot of perhaps difference of opinion. We are not offering the medical reports. 507, and I haven't seen these documents in a while, but that's Dr. Heisinger's 6-page report. But there are 2 pages of hand drawings, which we do want the jury to see, but they are going to perhaps have to be modified in some way. I believe, if I'm not mistaken, Dr. Fairstein's name is on one of them with Dr. Fairstein's number, his phone number, and so forth. It may be on the right-hand drawing. The outline is actually going to be, as I recall, 2 left hands because they're using a prepared outline of a human hand, which happens to be of the left hand, as I recall, to reflect both right and left. But we are offering the hand drawings. We are not offering the report itself. We are not offering 508, 509.
Let's deal with 507 first.
We are offering, Your Honor, that the alternative.
And what's your basis for offering it?
That it was authenticated by Dr. Heisinger, that it accurately reflects the body of information that he was given on June 15th. It accurately reflects observations about which he testified, and it provides a foundational basis for the jury to assess and evaluate the quality of his opinions concerning certain conditions of Mr. Simpson insofar as arthritic conditions, certain observations as to cuts. Dr. Heisinger was...
How do we overcome the hearsay objection?
Because it has sufficient guarantees of trustworthiness, Your Honor, and as well, it is offered to support the bases for Dr. Heisinger's opinions. He was subject to strenuous cross-examination, and I think it only fair that the jury be in a position to independently look at and evaluate those documents that were used to reach certain opinions that came under such ferocious attack, particularly given, as we now know, some of the instructions that the court will give based on some of the statements that Mr. Simpson made to Dr. Heisinger and implications that it appears the people argue from those statements. I think it only fair that the jury be given the chance to look at a document that was referred to and that was cross-examined very extensively about.
Your Honor, I don't think ferocious is exactly how I would describe the cross-examination. If that were the case, I think I took my life into my hands by laying on the counsel table and allowing Dr. Huizinga to perform a manipulation on me. I would say, however, that the hearsay...
I was about to direct your attention to the legal argument that I was interested in.
The hearsay problem cannot be overcome. First of all, we don't have 803.24 of the federal rule, the trustworthiness exception, when there is not another exception to the hearsay rule that's applicable. The drawings, however, qualify in essence as photographs. They are demonstrative evidence that Dr. Huizinga has authenticated to fairly and accurately represent the identification of certain injuries that he observed on June 15th of 1994, and clearly those are of significance to the jury's consideration of Mr. Simpson's guilt. They are not subject to hearsay. As I say, they are the equivalent of photographs, except that they are hand drawings.
All right, any comment as to 507A, which is the Elmo?
Your Honor, I have not seen, is there a pointer or something on that
Yes.
that we highlight something?
Yes.
Yes, I would offer that as well because of
Mr.
what it
Douglas?
is.
No objection to that.
All right. All right, the objection will be sustained to the report. I'll allow the withdrawal of the report. The drawings will remain. All right, Mr. Kelberg.
I'm sorry, are the two hand drawings?
Yes, will remain.
They will remain, okay. We're not offering 508, 509.
509 is not being offered?
Correct. These are all records of sedimentation rate and so forth. This was part of the examination regarding whether or not Mr. Simpson had evidence of an acute arthritic episode at or about the time of June 12, 1994.
All right, so you're not offering 509?
Not offering 509. That should be page 450 at the top on the discovery.
Mr. Douglas?
Fine, Your Honor.
All right, withdrawn.
As was 508, Your Honor.
All right, withdrawn.
And as is 510, that's Dr. Maltz's, I don't have the date, but it's 1992 examination. That has a sedimentation rate of 34. Not offered.
Fine, Your Honor.
Withdrawn.
We are offering 511, 512, and 513.
All right, I don't have any objections until 525.
We are offering 514.
Next is 522, Counsel.
Okay, I'm going to withdraw, or not offer it. Let me make sure. Okay, 522 is actually, I believe, Your Honor, 522A. I know that Mr. Lynch was asked by me to make sure that we substituted for both 521 and 522 the edited tapes that reflect only what was shown to the jury.
All right, 522A.
Right, so there should be a 521A, which is the actual video that was shown to the jury, which we are offering, not 521, which has more on it than was seen by the jury.
All right, I sort of have it the other way around. Oh, I'm sorry, I stand corrected, 521A. All right,
521A I have as that portion of the exercise video outtakes from May 25th of 1994, which was seen by the jury, and which is the videotape we are offering in lieu of 521, which is the full videotape, not all of which was seen by the jury.
all right, Mr. Douglas?
That's fine, Your Honor.
All right,
522A is the motivational speech, and that shows that portion of the motivational speech which was seen by the jury, and excludes that portion which is on the full video 522, which was not seen by the jury, and I understand there's an objection to that.
There was no authentication as to the date of that particular item. It was simply played for Dr. Huizinga. There was a representation as to what it reflected and when. They offered no other witness who came from the Juice Plus Company who was present at that particular speech, who could then properly authenticate the date or lay a foundation for its introduction. It is therefore not admissible in this present form.
Your Honor, could we put this aside for one moment? I have to confess that I informed Ms. Clark and other lawyers of the need to have a witness to lay a foundation.
And that was never done.
Okay, I'll take the court's representation was not done. I tried to follow it up. I was under the impression that there was either a resolution by stipulation or in some other manner it was resolved. If the court feels that there was no foundation, the question becomes one of relevancy. I will not object to counsel's objection, and I anticipate that the court will sustain it.
sustain. All right, 525, report by Dr. Jobe.
Withdraws my objection, Your Honor.
I'm sorry, 523 is not offered, Your Honor. I have to back up for a second. That's Dr. Martell's radiology consult report directed to Dr. Maltz.
All right, withdrawn.
524 is not offered. That is Dr. Maltz's chart entry from sometime in 1994.
525,
Is not offered.
all right, withdrawn.
And I believe then the only remaining exhibits that I'm responsible for are, to which there is an objection, would be 583 and 584. the videotape confessions of a medical examiner and an announcement. We are offering neither one of those,
All right, withdrawn.
and I believe that is it.
All right. Thank you very much.
May I be excused, Your Honor?
You are, sir. And as I indicated, I'll be here until, well, 6 o'clock at least.
Your Honor, if I find that we are having difficulties getting the packet, I'll notify the court and ask for relief till early tomorrow morning.
Well, how about later tonight? Because, Mr. Kelberg, I need to work on them as well.
I have every confidence we'll have them because they're primarily going to be the standard forms that the court wants to modify in the court's own fashion. So I think there's every reason we'll have them down there.
All right. Okay, Mr. Uelmen.
Yes, Your Honor.
We're paring down the list here. All right. Do you want to take it from the top with what's left?
Yes, Your Honor.
All right, 495, statement of Ellen Aronson.
And we submit that this is admissible as a prior inconsistent statement, Your Honor.
Your Honor, I think it's not properly foundation. No proper foundation was laid. It's still hearsay. It's not a proper document to be submitted or offered by the people in this case.
My recollection is that she was confronted with it, acknowledged that she gave the statement, but then later said that she was mistaken as to the time.
Exactly, Your Honor. And
All right.
that is a question of fact to resolve, but the foundation is properly made.
All right, the objection be overruled. All right, 498, statement of Denise Pilnick.
And we make the same argument, Your Honor. This is offered as a prior evidence of a prior inconsistent statement.
I'm not sure that it was inconsistent with the testimony in court, Your Honor. And I have the same objections as with the other.
She was confronted with regards to the time that she heard items,
Yes.
and she did acknowledge that she gave the statement.
Yes.
All right, but then she said that based upon other things, she had now a different opinion on the time.
Yes.
All right, objections overruled. Okay, 548.
The 531, Your Honor.
I'm sorry, 531?
Correct.
Mrs. Robertson, do I have that? Should be in my packet. All right, I'll ask Mrs. Robertson to look for that one. Would you note that? Which one? Which number is that? 531? I'm sorry, 531. Got it. All right, 531, 530. Yeah, 531.
Yes, that apparently, in reviewing the transcript in volume 190, it was marked at page 3777. Ms. Clark was interrupted as she marked it, so the full citation isn't there, but it was marked at that page. There was an extended discussion at sidebar regarding this issue. Ms. Clark questioned the witness regarding the existence of a dome light, and I believe the witness stated, according to the transcript, that he lacked a recollection one way or the other if the dome light went on, and he denied knowledge of how the dome light works in a Ford Bronco. We would submit
Which witness was this?
John Murad.
John Mraz, Your Honor.
All right.
We would submit that that the photograph was marked and that he was questioned regarding it. Whether or not this has much probative value will be up to the jury when we submit the foundation.
What occurred, Your Honor, if I can recall, because I was present in court, was there was an objection upon the presentation or the marking of the exhibit. Ms. Clark was requested to try to lay a foundation before offering it or showing to the witness. She was unable to. That is why she did not offer the actual exhibit to the witness.
All right, that's 531. The objection will be sustained. Lack of foundation. All right, next item.
Is that People's 548, Your Honor?
Withdraw that objection, Your Honor.
All right, withdrawn. The objection is withdrawn, I'm sorry.
Correct.
All right, 578. I'm sorry, 570 and 571. Do you have those charts available, Mrs. Robertson?
And, Your Honor, I'm going to defer to Mr. Clark on that issue.
Good afternoon, Your Honor.
Good afternoon, Mr. Clark. Long day.
These arguments basically parrot those that were made when the boards were first presented, if you'll recall. Mr. Scheck objected both on 352 and on grounds that is cumulative to the results of the RFLP DNA Analysis Board.
All right, matter submitted?
Correct.
Yes, I assume these are preserving objections.
Right. All right, the objection be overruled.
Thank you.
All right, 578.
I can also answer for that. That is, I believe, 2 pages of transcript that were used in testimony and otherwise is submitted to the court.
Submit. I don't think it's appropriate that we would highlight any particular witness or any particular aspect.
Refresh my recollection. What did we use this for?
Bruce Weir.
It was previous testimony of Dr. Weir used with Dr. Speed.
Correct.
And it was used to clarify the witness's understanding of previous testimony by Dr. Weir.
All right, I'm going to sustain the objection. All right, 587.
Thank you, Your Honor.
Thank you, counsel. I'm sorry, 583. That's been withdrawn. 584 been withdrawn. 587.
And yes, Your Honor, we are offering this as a prior inconsistent statement to impeach Dr. Reeders with respect to knowing that Deputy District Attorney Kevin Denoce, D-E-N-O-C-E, to knowing him and of receiving the 1985 autopsy tissue. And we would submit that a foundation was laid with Dr. Reeders.
Your Honor, I'm referring to page 41636, line 15, where he was shown that bill and said he didn't know, he didn't recognize it. It was never authenticated.
He said it was done by the billing department, and he doesn't do the billing.
So he never identified it.
Well, the fact that he's familiar with the practices of the billing department would give some indication that this is a legitimate bill and that the date is accurate. The real issue is, we believe, is the hearsay issue, and that has been, that was laid as a prior inconsistent statement.
After he said, I don't know, there were never any further questions asked about the billing system, the billing department. It just never went any further.
All right, I have in my notes 41638, not 36. So I'll check my transcript again, and I'll let you know. What volume is that in, Mr. Blazier?
I don't have volumes, but it's August 14th.
All right. Thank you. All right, number 588.
And we are submitting that this is simply impeachment of Dr. Reeders. It demonstrates that the various tissue samples were sent to Dr. Henyon by Dr. Reeders.
As the court might recall, and I refer you to page 41641, line 22, this was the report that he had never seen. Remember, there were 2 reports, and this was the other one, and the one that he was familiar with was never introduced. So I would object to it. It was never identified.
All right, any other response, Mr. Yeltsin?
Submitted, Your Honor.
All right, the objection be sustained. Okay,
Next is 613, Your Honor.
613. This is something that was not offered before the jury,
Correct.
so it remains in evidence, however, is not something that will go before the jury. Mr. Yeltsin?
Thank you. I will submit it.
All right. So, Mrs. Robertson, this remains in the record, but hold on to it, doesn't go into the jury room.
Your Honor, could it be made a court exhibit as just so it's
No,
easier?
no, it remains as part of the record. It's just something that doesn't go to the jury. Since it was used for the legal issue regarding the continued RFLP testing from the console. By the way, is Mr. Neufeld ever going to collect his Bronco console out of my chambers?
I'll remind him this afternoon, Your Honor.
All right, since it appears we're not going to use it for anything. All right. Makes a dandy coffee table. All right, last one, 617.
If I'm not mistaken, Your Honor, that document was used to refresh Mr. Opler's recollection offered by the people with the hearsay, and I object.
And we were offering it, Your Honor, as a prior consistent statement of Mr. Opler after he'd been cross-examined on the issue, and therefore... Excuse me one moment, Your Honor.
Mrs. Robertson, would you ask Mr. Byrne to pull the transcript that goes with this, please?
Excuse me, Your Honor. Again, we were offering this for as an exception to the hearsay rule and for the truth of the matter asserted as a prior consistent statement. It also comes in the alternative for a non-hearsay purpose, simply to show that these items were delivered on the dates that they were allegedly delivered.
Are we talking about 617?
My recollection was that the report saying I went to this house and took this video, and someone else was present.
Mr. Yelpis, let me show you the exhibit.
Yes, and Your Honor, it's simply a report of no substance other than the delivery of a video, I believe.
I refresh my recollection as to what is a prior consistent statement.
Perhaps I'm misinformed.
It says I went there, this is who was with me, this is what we did, we came home.
Your Honor, Mr. Goldman was present during this.
Goldberg.
Goldberg was present during this presentation of the testimony. I'm going to defer to him.
Actually, I think I overheard this part of the testimony. I'm not sure whether I was actually in court. I may have been heard it on the radio. I can't remember for sure now. There was a portion of the cross-examination of Stephen Oppler where this particular report came to light, and it was brought out that it had not been turned over, the implication being that there was some sinister reason behind it. And what the prosecution wanted to do, and the reason for eliciting this, I believe, on redirect, was to show that there is nothing of substance in the report, that is merely him saying, I went to the location at a certain date and time, and stating the specific numbers of the videotape that was used to actually record the substance of the conversation. So the reason that is being offered is not for the truth of the matter asserted, because there is really nothing in it of truth to assert that's in contest. The purpose is simply to show that there is nothing of substance, there is nothing that he's trying to hide, and we want the jury to be able to look at it for that purpose, to try to refute some of the allegations that were made groundlessly by the defense in this regard.
Well, the allegation was that it was never turned over. That is true. That factor is not resolved by simply showing the statement, and it's still, Mr. Goldberg's explanation does not overcome the hearsay objections. The fact that it is not offered to be consistent with any prior statement, I don't think that that's a proper basis to introduce any kind of document for technical reasons. I think certainly the mileage that he wants to get out of it has already been earned in that the jury was informed of the innocuous nature of the document, but that still doesn't overcome the hearsay objections that I think are proper.
All right, but I think a foundation was laid here. The witness did say what it was, identified what it was. Given the context of the discussion that went on, I'm going to overrule the objection. All right, does that conclude that stack?
It does, Your Honor.
Yes, Your Honor. We have the...
All right, now the objections to the defense exhibits. Okay. The one objection of substance is to 1373 and 1375. 1373 being the description of the sewing patterns. Mr. Blazier?
My recollection of that is that Mr. Rubin did testify that these were different kinds of ways of making stitching on the back of gloves as well as stitching the fingers. He did say that he didn't think they looked like that, but he did identify those as different variations on stitching, so we would offer it for that purpose.
It's my understanding that Mr. Rubin also testified that these are color photocopies as opposed to original.
No, all it is...
In other words, the images were too unclear for him to make a clear determination. We would submit that pursuant to Evidence Code Section 352, this evidence is misleading because it does not provide that kind of an image, and therefore the prejudicial effect outweighs the probative value. We would ask it to be excluded for that reason. And we would also indicate that there is no foundation for the admission of this based on the fact that Mr. Rubin simply couldn't identify the images there because the images themselves were not distinct.
No, he said he recognized several of these, didn't recognize all of them as ones that he was familiar with, but he did say that a number of these were common to the trade. So the objection will be overruled. All right, what else do we have? 1375.
Your Honor, Mr. Harris has now endeavored to prepare a redacted Paratus videotape showing the mouthing of the words, I don't remember, and also showing the 14-minute gap about which there was cross-examination of Mr. Oppler. We can mark it as 1375A if the court pleases. We can substitute it if the court pleases, however the court wishes to do. I would just assume substitute it for 1375.
Your Honor, I wasn't in court when that portion of the tape was played, or if it was played. I don't know whether it was. What was that? It was played? Okay.
I think I've seen it now 5 times.
No, I remember we
No, the
played
jury saw it
during
once.
the 402 hearing,
Yes.
but I can't remember that it was played in front of the jury.
Yes, it was.
And I assume that the gap in the tape was already played in front of the jury as well?
Yes.
All right. Well, our argument as to why that should not be admitted at this time is because we have subsequently put on testimony of 2 witnesses explaining those events, and there is no relevancy to them. I happen to believe that, particularly where allegations of misconduct are being made, and that seems to be what counsel was making, that they should be made in good faith, particularly where they are addressed towards another lawyer. And I don't think that it is proper or should have been allowed for that kind of questioning to have been made, in my view, in bad faith without any factual basis whatsoever to suggest that these witnesses or Mr. Opler was perjuring himself and somehow this witness has been coerced or improperly coached. But it has been done. I think now the record has probably been set straight on that with 2 witnesses. I don't think the defense should be allowed to argue it any further. And I don't think that evidence that's being offered to support something that isn't true should be allowed.
Mr. Goldberg perhaps might be a little bit sensitive right now, but if the court will recall, Mr. Opler was asked whether or not there was a 14-minute gap, and he said no, or that he didn't recall, or that there wasn't one. He was then shown the counter which demonstrated the 14-minute gap. He was also asked whether there was an occasion when the witness appeared to mouth words, "I don't remember," which we felt was illustrative of some prior communication that may have happened before this occasion of the taping between someone in the DA's office and Mr. Paradas. Again, when he was shown the videotape, it then refreshes recollection. He can now appreciate the nature of the question. Both questions were made in good faith. There was, in fact, a gap. There was, in fact, mouthing of words that the witness did not recall. And I think for those reasons it's admissible, Your Honor. And we have a redacted copy only of those portions being inserted.
To me, it is not a gap, Your Honor, where you end the interview, you forget to ask a question, and you start up the interview again, and then you turn everything over to the defense. I don't think that the purposes for which it were introduced are as innocent as counsel claims. And I also don't understand how, when the prosecution had been ordered to redact the tape and had redacted it pursuant to the court's orders, that then suddenly the defense is allowed to selectively place certain other portions in the tape that they like and then make it appear that the prosecution somehow improperly redacted it, when initially we wanted to play the whole unredacted version to begin with. I think that this is a misleading issue. I do not believe that the implications of the defense line of questioning were in good faith. I do not believe that there's a factual basis for them. I don't think that they should be allowed to introduce further evidence or to argue this issue in front of the jury.
Those exact arguments, Your Honor, if the court will recall, were made by Ms. Clark at the time. Mr. Kelberg wasn't here, and the court overruled them.
All right. Objection will be overruled. All right, last matter is 587.
May have been what you were referring to, where Dr. Reeder said, "I have no idea what this is."
That's what I had in my notes. All right, the objection be sustained on foundational grounds. All right, anything else?
1375, can we simply substitute our redacted version showing the video? Or do you want me to mark it with?
No, the redacted version would have to be 1375A.
Very well.
All right, anything else? Any other exhibits we need to discuss?
Your Honor, I have a note here. Exhibits 1374A and B indicated that these were done before Mr. Sims without the jury present.
And withdrawn.
All right, they're withdrawn? All right.
A and B are both withdrawn then. And then with respect to 1375, we talked about that. Thank you, Your Honor.
All right, anything else, Mr. Douglas?
No, Your Honor, thank you.
Ms. Deutsch, anything else? Thank you.
Your Honor, can we expect tomorrow to hear from the District Attorney's Office as to the thoughts that we mentioned on scheduling?
I would hope so,
Thank you.
because it will take significant planning.
We'll have an answer on that, hopefully first thing in the morning, and perhaps I can call Mr. Douglas tonight
All right.
with some word.
It would be my hope and expectation that we can do that, because we have an unusual confluence of bad timing calendar-wise.
And in view of that, Your Honor, though, our preference would be to argue some portion of the day on the 29th. The alternative that we suggested, and that is going until perhaps 9 or 10 o'clock on the 26th, the 27th, and the 28th, with hopes of at least concluding the defense argument by the close of business in the evening of the 28th would be appreciated. We would like, however, Your Honor, if the Court pleases, to, in view of the particular aspects of this scheduling problem, to consider or sleep on and rethink perhaps limiting the extent of the people's opening closing argument to perhaps the equivalent of 2 normal days or maybe 10 hours, so that we could perhaps squeeze in the people's argument in maybe an extended day and a half, and then have the defense portion in the remaining extended day and a half.
And, Your Honor, on that issue of limitations on the people's argument, I can give that answer now. People would object to any such limitations. And I'll take up the other matter tonight.
All right, well, it's the Court's desire to do that, convey that to your,
I'll convey that, Your Honor.
and in fact, it's the Court's expectation that that's what we're going to do.
Again, Your Honor, I'll convey that. I can't commit until we discuss it. Thank you.
Thank you, Your Honor.
Your Honor, there's one.
I might just make an observation that it's not uncommon across the street, and it's not uncommon in other parts of the country.
Yes, we discussed that in chamber.
Your Honor, there is one more matter.
Yes, Ms. Liss.
Earlier this afternoon, I filed a motion with regard to defense, what we would believe would be improper defense commentary. Hearing closing argument with regard to Mark Furman's having taken the Fifth Amendment, and with regard to any mention by the defense of any portion of the tapes, McKinney tapes and transcripts, which the Court did not admit. We've also requested that they be warned in advance of a jury admonition to be given in the event that in Mr. Cochran's zeal he lets slip something like that. And I served that upon Mr. Douglas and Mr. Uelmen earlier this afternoon. Can we handle that tomorrow morning?
Well, I expect that there will be vigorous opposition to the unprecedented attempts to impose some sort of a instruction that is not warranted by the facts or the law. I neglected, unfortunately, because Mr. Uelmen was involved with arguing instructions, to give him a copy when it was handed to me around 2:30 or so. I would hope, Your Honor, that this particular matter can be handled before arguments begin on Tuesday. I don't think that the issue necessarily becomes ripe tomorrow, and I would not want to commit Mr. Uelmen without having a chance to show him the document and getting his thoughts.
Yeah, Mr. Uelmen, I did give him I put a copy right in front of him in addition to handing one to Mr. Douglas, so he probably has it.
All right. Well, we'll take it up probably Tuesday morning, and if you recollect, we need to get here early Tuesday to look at tape snippets and other items.
8 o'clock, as I recall.
8 o'clock, that's
Okay.
correct. So it's going to be a long day for some of us. All right.
Thank you, Your Honor.
One other matter, Mr. Douglas, forgive me if I've already mentioned this to you, but I have a little posted here reminding me to take a waiver from your client tomorrow.
Sure.
All right, so he's prepared.
Very well.
Okay. Right to testify.
Right. Thank you, Your Honor.
Has either side rested, Your Honor?
No, they're going to rest. Our game plan is that tomorrow, out of the presence, I'll take the waiver from the defendant. In the presence of the jury, both sides will rest, and then I will instruct the jury.
Thank you, Your Honor.
All right, we'll stand on recess till, as far as the jury is concerned, 10 o'clock tomorrow morning. And let's see, is there anything else we need with regard to counsel tomorrow morning? Let me see counsel tomorrow morning at 9 o'clock in case there are any last-minute issues on instructions. All right,
That's fine, Your Honor.
All right, we'll stand on recess. Thank you, counsel. Mr. Simpson is again present before the court with his counsel. Let's have it quiet in the courtroom, please. Mr. Simpson is present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Neufeld, Mr. Uelmen, people represented by Ms. Clark, Mr. Darden, and Mr. Kelberg. Jury is not present. The record should reflect that the court has conducted an off-the-record in-chambers conference with counsel to conclude our discussions concerning the jury instructions. And so that the record is clear, the prosecution has withdrawn their request for instruction 8.31, second-degree murder on an implied malice theory. They have withdrawn that. They have also withdrawn 8.25, murder by means of lying in wait as a theory of premeditation. The record should reflect that the court has modified 220 at the request of the defense to include any influence that might be exerted upon a witness at the time of their testimony by any drug, alcohol, or other substance. The court has heard argument in chambers regarding the DNA instruction that the court intends to give. And I've heard the argument regarding the request that the court instruct on a laboratory error rate as a phenomena that should be considered by the jury. Any other comment on that particular issue? This matter submitted?
Submitted, Your Honor.
Submitted? All right, I have contemplated this issue. This is unfortunately an area where instructions from other courts and approved by the courts of appeal in various states, there is not an overabundance of guidance to the trial court. I believe that the argument that laboratory error rate should be considered is a valid argument. And I will include the following two sentences on the court's special instruction number 3. Frequency estimates and laboratory error rates are different phenomena. Both should be considered in determining what significance to attach to blood stain testing results. All right, any other comment on instructions before we invite the jurors to join us? Gentlemen?
For the record, Your Honor, with respect to the rulings that we were informed of this morning, we would like to reiterate our objection to the special instruction that the court proposes to give on Section 403 of the Evidence Code. We believe that giving this instruction will be prejudicial error because it deprives the defendant of a factual determination by the jury of the chain of custody issue to which he is entitled under Section 403 of the Evidence Code. And I know Your Honor noted in denying our pretrial motion challenging the admission of the evidence from the Bronco that chain of custody would be an issue for the jury to consider, but we believe that this instruction deprives us of a jury determination of that issue by submitting it to them just in general terms of relevancy, rather than requiring a finding of the preliminary fact that a chain of custody was observed. Secondly, we want to object to the court giving Section 271 and 272. We believe this highlights the prejudice to the defendant in the admission of the Ron Shipp testimony, since the court has indicated this is the only basis on which the jury will be instructed that they can find an admission by the defendant.
I don't think that's correct. I indicated that Mr. Kelberg's argument that statements made by a defendant that are later shown to be untrue or in some way assist the prosecution, those are legally defined as admissions.
Even if they refer to the prior similar acts admitted under Section 1101.
No, there are other comments.
We further object to the denial of the court by the court of the proposed instruction D33 relating to the demeanor of the defendant. Your Honor indicated that you thought the reasonable doubt instruction would cover that.
Reasonable doubt, burden of proof.
We believe that the defendant is entitled to an instruction with respect to his theory of the case, and the demeanor evidence was a very important part of the defense's theory of the case. And finally, we would like to make one more request, that the court at least instruct the jury that Detective Mark Furman is an unavailable witness without any comment as to any conclusions to be drawn from that fact. We believe the defense is significantly prejudiced by the jury being sent out to decide this case without any information as to what became of Detective Furman.
All right, thank you, counsel. Mr. Kelberg, any response?
Yes, Your Honor. Again, I don't think there's any basis to highlight that, number one. Number two, I don't think anyone's going to argue from the prosecution perspective the failure of the defense to bring back Detective Furman in any way is going to strengthen the inference of guilt in this matter. The credibility issue is obviously there, and no one's going to hide from it. With respect to the other request by Dean Uelmen, obviously I agree with the court's ruling on D33. I don't think I need comment on that. I think the record should reflect that because we have withdrawn a theory of implied malice for second-degree murder, that we've asked the court to conform other instructions that, for example, 3.31 has modified to strike any reference to implied malice wherever it may appear. I think the court has indicated it was going to do so in those additional instructions. With respect to the Furman matter, one last point is I believe legally that it violates the evidence code provision, which I do not believe is unconstitutional as applied to a witness, to have an adverse inference drawn from the proper invocation of a privilege, and to tell the jury about unavailability invites speculation instead of staves off speculation. So I would request the court to keep the record as it is on the jury instructions with respect to Mr. Furman and have the general instructions applied. Thank you.
All right. I think I'm bound by the ruling of the Court of Appeal on that issue, so I'll decline the request. All right, one last thing that we need to discuss. Mr. Cochran, I indicated to you previously that I wanted to make certain, my understanding is that the defense is going to rest today, as is the prosecution in front of the jury, and that your client, you've discussed with your client his right to testify as a witness, and it's your choice and his agreement that the defense rests at this time without presenting his testimony.
Yeah, that's fine.
Yes.
Good morning, Your Honor. In this regard, just two quick things, if the court pleases. We do, at the time we rest, we will move the court for a motion of acquittal on behalf of Mr. Simpson and submit that, if the court pleases. And Mr. Simpson would like to make a brief statement with regard to the purported waiver. Mr. Simpson would like to make a brief statement regarding the purported waiver, if the court pleases. And
This is his knowledge that he has the right to testify.
yes. And then with regard to the last thing, we would, at the appropriate time, move the balance of our exhibits and evidence whenever you deem that's appropriate. Mr. Douglas has some redacted some numbers for redacted videos and various things.
All right.
Your Honor, the people would object to him making any statement in court other than a waiver. That is the only appropriate statement that he should be making on the record at this time.
All right. It's not before the jury at this point.
Your Honor, you know, we are all aware of the realities of life in this case, and the problem with conjugal visits, and the problem with telephone calls that are only monitored on one side. And this is a very obvious attempt by the defense to, again, get material admitted through those conjugal visits and telephone calls that has not been admitted in court. I urge the court strenuously to exercise control here, take the waiver, and do not permit, basically, allocution. That is testimony without any cross-examination. It's inappropriate. It's done very deliberately by the defense for a clear purpose. Please don't do this, Your Honor. I beg you. I beg you, take the waiver and let the defendant admit that he will not testify and waive his right, but nothing further should be said on the record and in open court. May I have a moment, please? Mr. Kelberg points out, absolutely correct, that all the court need do at this time is advise Mr. Simpson of his right to testify, that it is his personal right to use and to invoke, that he may testify over the objections of his lawyers if he so chooses, and that if he declines to do so, then he has waived that right. And that is all the court need do.
Briefly.
This is still America, and we can talk, we can speak. Nobody can stop us from speaking. The court asked me about Mr. Simpson. I just respectfully indicated to him that he wanted to just briefly address the court. It's interesting that this length of time, and I don't want to sink to this at this point. I want to get this case over with. We won't start the arguments until Tuesday. But the court asked about the waiver. He has a right to speak with regard to the waiver, and they can't stop him from speaking. And that's what it boils down to, Your Honor. So I think
It also boils down to the court can control the orderly process, and all I'm interested at this point, now that I've been told that the defense intends on resting and not presenting any further witnesses or any further evidence other than their proffer, that Mr. Simpson understands his right to testify as a witness, and that after discussing that with his lawyers, he's making an intelligent decision not to testify.
The court asked me about that. That indicated the court, Mr. Simpson.
Yes.
I'd like to respond to the court.
Right.
Personally.
Mr. Simpson, good morning, sir.
Good morning, Your Honor. As much as I would like to address some of the misrepresentations made about myself and Nicole concerning our life together, I'm mindful of the mood and the stamina of this jury. I have confidence, a lot more it seems than Ms. Clark has, of their integrity, and that they will find, as the record stands now, that I did not, could not, and would not have committed this crime. I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer?
All right.
Is this trial over? Thank you.
All right. Mr. Simpson, you do understand your right to testify as a witness?
Yes, I do.
All right. And you choose to rest your case at this? All right. Thank you very much, sir. All right. Mr. Douglas, you have a motion to move the defense exhibit subject to redaction of various videotapes.
Thank you, Your Honor. Court, please, this morning. We have a redacted version of Exhibit 1104, which I'd like to label as 1104A. We have a redacted version of Exhibit 1103, which I
Making it short.
label 1103A. We have a redacted version of Exhibit 1002, which I would like labeled 1002A. We have a redacted version of Exhibit 1102, which I'd label 1102A. And we have a redacted version of 1375, which I would label 1375A. Thank you.
Any comment?
No comment on that, Your Honor.
All right, they'll be
We
received.
have exhibits to mark as well. I'd like to substitute 527A for 527. I'll give it to Ms. Robertson. I'd like to mark the Sonoporatus tape 615A as the tape shown at the 402 hearing. And
That's the entire tape.
Yes.
All right.
And I'd like to withdraw 599 through 601. May I also, Your
They
Honor,
are what?
they are two of the planners and the telephone book of the defendant.
All right.
May I also ask, Your Honor, for the court to inquire of Mr. Simpson, perhaps he would allow me then the opportunity, since he would like to make these statements to the court, I would like the opportunity to examine him about them. May he take a seat in the blue chair, and we'll have a discussion?
Thank you.
Your Honor, there is one other matter. Just for the record, the court had requested that I inquire on the people's position regarding Staples. And I had made the inquiry. It's my understanding that Staples will not be a matter of consideration in argument unless it's raised by the defense in their argument, and as a result, we feel that that will resolve the issue.
All right, thank you. All right, one other thing, I am going to make inquiry of the jury when we have them out here. I'm going to ask them to contemplate the proposal to extend the argument, the court hours for the purposes of concluding argument. And I indicated to you that I will make inquiry to change my plans for Friday, September the 29th, to see if we can have a full court day on that date.
Maybe address this week, Your Honor.
I'm sorry?
Maybe address this week, suggestion.
Well, no, we've had our informal discussion. I need to see what my schedule looks like. I want to see what the jurors are willing to do. That's what I just said. All right, anything else before we invite the jurors to join? I'm sorry, Mr. Cochran, you wanted to make an 1181 motion, I thought.
Yes, Your Honor, I would just briefly move for a judgment of acquittal pursuant to 1181 of the Penal Code and submit it.
Ms. Clark? All right. Motion will be denied. All right, Deputy Smith, let's have the jurors, please. I'm sorry, I just have my original here. All right.
Don't make me work right now. I'm trying to make a short. I need to make a short of OJ Simpson talking. It's very important. Can't believe I have to work right now. Oh, this is a long one, too.
On behalf of the defense, do you have any further testimony or evidence to present?
Good morning, Your Honor. Good morning, ladies and gentlemen. Your Honor, I'm very pleased to say that we have no further testimony to present at this time, and as difficult as it is, the defense does rest at this point. Thank you.
Ms. Clark, on behalf of the people?
Yes, thank you, Your Honor. Good morning, ladies and gentlemen. We ask the court to receive all of the people's exhibits, and the people rest.
All right. On receipt of the exhibits from both sides having now rested. Ladies and gentlemen, as you heard, the counsel for both the prosecution and defense have rested their case. There will be no further testimony or
Yes, you
evidence
just
presented
did, John.
to you.
I'm making it short.
And it is now going to be my duty to instruct you on the law that applies to this case. After I finish instructing you on the law, then we will hear the arguments of the attorneys, and that will commence on Tuesday, September the 25th. On Monday, September the 25th, I will be here with the attorneys who are available. We will organize all the exhibits so that when the argument commences, it will go forward in an orderly and efficient and quick manner, I hope. Having said that, there is a proposal that has been made that I am contemplating with regard to the arguments by the attorneys, and that is to extend the court hours for next week. The proposal is to start with the normal morning session at 9 o'clock, go until noon, start the afternoon session, and go to approximately 5 or 6 in the evening, take a break for an evening meal, and then have a session in the evening to approximately 8 or 9 o'clock in the evening. And it's my feeling that by doing that, that we can finish the arguments perhaps next week or as soon as possible thereafter. I know, however, that that would disrupt your schedule. It would place an extra burden on the court staff, and this is something that I have not decided yet to do. But I would like your input to see whether or not you would be willing to stay for an additional evening session each day until we have concluded the arguments. And I'm actually seeing, I've seen 8 nods affirmative. I see smiles. Everybody? Well, we have one unanimous decision already. All right. All right, then this is also subject, I also have, as you know, I have to make arrangements to get you all fed. The bailiffs have to change their schedule. I might have to bring in a third court reporter. It will be, I have some logistical things to do before we make that in stone, but I wanted first to know whether or not you were willing to do it. And having gotten an affirmative answer, I will pursue that this afternoon. All right, ladies and gentlemen of the jury, you have heard all, excuse me, I'm sorry, and Deputy Bashmakian, now that I'm starting the instructions, nobody is to enter or leave the courtroom during the court's instructions. All right, ladies and gentlemen of the jury, you have heard all the evidence, and it is now my duty to instruct you on the law that applies to this case. After I conclude reading these instructions to you, we will commence with the argument of counsel. The law requires that I read these instructions to you here in open court. Please listen carefully. It is also my personal policy that you will have these instructions in their written form in the jury room to refer to during the course of your deliberations. You must base your decision on the facts and the law. You have 2 duties to perform. First, you must determine the facts from the evidence received in the trial and not from any other source. A fact is something that is proved directly or circumstantially by the evidence or by stipulation. A stipulation is an agreement between the attorneys regarding the facts. Second, you must apply the law that I state to you to the facts as you determine them, and in this way arrive at your verdict and any finding you were instructed to include with your verdict. You must accept and follow the law as I state it to you, whether or not you agree with the law. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. You must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the prosecution and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. If any rule, direction, or idea is repeated or stated in different ways in these instructions, no emphasis is intended, and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole and each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by attorneys during the trial are not evidence. Although if the attorneys have stipulated to or agreed to a fact, you must regard that fact as conclusively proven. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it enables you to understand the answer. Do not consider for any purpose any offer of evidence that was rejected by the court or any evidence that was stricken by the court. You must treat it as though you had never heard it. You must decide all questions of fact in this case from the evidence received here in court in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there has been no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works or persons for additional information. You must not discuss this case with any other person except a fellow juror, and you must not discuss the case with a fellow juror until the case is submitted to you for your decision, and then only when all 12 jurors are present in the jury room. Evidence consists of the testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. It is evidence which, by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct evidence and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible of 2 reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. If you find that before this trial the defendant made a willfully false or deliberately misleading statement concerning the crimes for which he is now being tried, you may consider such statement as a circumstance tending to prove consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your determination. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, you were admonished that it could not be considered by you for any other purpose other than the limited purpose for which it was admitted. Do not consider such limited evidence for any purpose except the limited purpose for which it was admitted. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. Testimony given by a witness at a prior proceeding who was unavailable at this trial has been read to you from the reporter's transcript of that proceeding. You must consider such testimony as if it had been given before you in this trial. With the exception of Nurse Thanoparatus, evidence that on some former occasion a witness made a statement or statements that were inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on such former occasion. Evidence of the Thanoparatus videotape statement, which is People's Exhibit 615, which may include statements that were consistent or inconsistent with his former testimony presented by reading the transcript of his former testimony given at the preliminary hearing, may be considered by you solely for the purpose of testing the credibility of Mr. Paratus' former testimony. If you disbelieve a witness' testimony that he or she no longer remembers a certain event, such testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the believability of a witness and the weight to be given the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency in reason to prove or disprove the truthfulness of the testimony of the witness, including but not limited to any of the following: the extent of the opportunity or the ability of the witness to see or hear or otherwise become aware of any matter about which the witness has testified, the effects, if any, from the use or consumption of alcohol, drugs, or other intoxicants by the witness at the time of the events about which the witness has testified or at the time of his or her testimony, the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of that testimony, the demeanor and manner of the witness while testifying, the existence or non-existence of a biased interest or other motive, evidence of the existence or non-existence of any fact testified to by the witness, the attitude of the witness toward this action or toward the giving of testimony, a statement previously made by the witness that is consistent or inconsistent with the testimony of the witness, the character of the witness for honesty or truthfulness or their opposites, an admission by the witness of untruthfulness. Discrepancies in a witness's testimony, or between his or her testimony and that of others, if there were any, do not necessarily mean that the witness should be discredited. Failure of recollection is a common experience, and innocent misrecollection is not uncommon. It is also a fact that two persons witnessing an incident or transaction often will see or hear it differently. Whether a discrepancy pertains to a fact of importance or only to a trivial detail should be considered in weighing its significance. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who has willfully testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. You are not bound to decide an issue of fact in accordance with the testimony of a number of witnesses which does not convince you, as against the testimony of a lesser number or other evidence which appeals to your mind with more convincing force. You may not disregard the testimony of the greater number of witnesses merely from caprice, whim, prejudice, or from a desire to favor one side as against the other. You must not decide an issue by the simple process of counting the number of witnesses who have testified on the opposing sides. The final test is not in the relative number of witnesses, but in the convincing force of the evidence. You should give the testimony of a single witness whatever weight you think it deserves. However, testimony by one witness which you believe concerning any fact is sufficient for the proof of that fact. You should carefully review all evidence upon which the proof of such fact depends. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which his or her testimony pertains. A duly qualified expert may give an opinion on questions in controversy at a trial. To assist you in deciding such questions, you may consider the opinion with the reasons given for it, if any, by the expert who gives the opinion. You may also consider the qualifications and the credibility of the expert. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. You may disregard any such opinion if you find it to be unreasonable. In examining an expert witness, counsel may propound to him or her a type of question known in the law as a hypothetical question. By such a question, the witness is asked to assume to be true a set of facts and to give an opinion based upon that assumption. In permitting such a question, the court does not rule and does not necessarily find that all the assumed facts have been proved. The court only determines that those assumed facts are within the probable or possible range of the evidence. It is for you, the jury, to find from all the evidence whether or not the facts assumed in a hypothetical question have been proved. If you should find that any assumption in such question has not been proved, you are to determine the effect of that failure on the proof. You are to determine the effect of that failure of proof on the value and weight of the expert opinion based upon the assumed facts. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against that of another. In doing this, you should consider the relative qualifications and credibility of the expert witnesses, as well as the reasons for each opinion and the facts and other matters upon which it was based. In determining the weight to be given the opinion expressed by any witness who did not testify as an expert witness, you should consider his or her credibility, the extent of his or her opportunity to perceive the matters upon which his or her opinion is based, and the reasons, if any, given for it. You are not required to accept such opinion, but should give to it the weight, if any, to which you find it to be entitled. The court has admitted physical evidence, such as blood, hair, and fiber evidence, and experts' opinions concerning the analysis of such physical evidence. You are the sole judges of whether any such evidence has a tendency and reason to prove any fact at issue in this case. You should carefully review and consider all the circumstances surrounding each item of evidence, including, but not limited to, its discovery, collection, storage, and analysis. If you find any item of evidence that does not have a tendency and reason to prove any element of the crimes charged, or the identity of the perpetrator of the crimes charged, you must disregard such evidence. You have heard testimony about frequency estimates calculated for matches between known reference blood samples and some of the bloodstain evidence items in this case. The random match probability statistic used by DNA experts is not the equivalent of a statistic that tells you the likelihood of whether a defendant committed a crime. The random match probability statistic is the likelihood that a random person in the population would match the characteristics that were found in the crime scene evidence and in the reference sample. These frequency estimates are being presented for the limited purpose of assisting you in determining what significance to attach to those bloodstain testing results. Frequency estimates and laboratory errors are different phenomena. Both should be considered in determining what significance to attach to bloodstain testing results. Evidence has been introduced for the purpose of showing that the defendant committed crimes other than that for which he is on trial. Such evidence, if believed, was not received and may not be considered by you to prove that the defendant is a person of bad character or that he has a disposition to commit crimes. Such evidence was received and may be considered by you only for the limited purpose of determining if it tends to show a characteristic method, plan, or scheme in the commission of criminal acts similar to the method, plan, or scheme used in the commission of the offense in this case, which would further tend to show the existence of the intent, which is a necessary element of the crime charged, the identity of the person who committed the crime, if any, of which the defendant is accused, or a clear connection between the other offense and the one of which the defendant is accused, so that it may be inferred that if the defendant committed the other offenses, the defendant also committed the crimes charged in this case. The existence of the intent, which is a necessary element of the crime charged. The identity of the person who committed the crime, if any, of which the defendant is accused. A motive for the commission of the crime charged. For the limited purpose for which you may consider such evidence, you must weigh it in the same manner as you do all the other evidence in this case. You are not permitted to consider such evidence for any other purpose. Within the meaning of the preceding instructions, such other crime or crimes purportedly committed by a defendant must be proved by a preponderance of the evidence. You must not consider such evidence for any purpose unless you are satisfied that the defendant committed such other crimes or crimes. The prosecution has the burden of proving these facts by a preponderance of the evidence. Within this limited context, preponderance of the evidence means evidence that has more convincing force and the greater probability of truth than that opposed to it. If the evidence is so evenly balanced that you are unable to find that the evidence on either side of an issue preponderates, your finding on that issue must be against the party who has the burden of proving it. You should consider all the evidence bearing upon every issue, regardless of who produced it. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish guilt. Absence of motive may tend to establish innocence. You will therefore give its presence or absence, as the case may be, the weight to which you find it to be entitled. A defendant in a criminal trial has a constitutional right not to be compelled to testify. You must not draw any inference from the fact that a defendant does not testify. Further, you must neither discuss this matter nor permit it to enter into your deliberations in any way. In deciding whether or not to testify, the defendant may choose to rely upon the state of the evidence and upon the failure, if any, of the prosecution to prove beyond a reasonable doubt every essential element of the crime charged against him. No lack of testimony on the defendant's part will make up for a failure of proof by the prosecution so as to support a finding against him on any such essential element. An admission is a statement made by the defendant other than at his trial, which does not by itself acknowledge his guilt of the crimes for which such defendant is on trial, but which statement tends to prove his guilt when considered with the rest of the evidence. You are the exclusive judges as to whether the defendant made an admission, and if so, whether such statement is true in whole or in part. If you should find that the defendant did not make the statement, you must reject it. If you find that it is true in whole and in part, you may consider the part which you find to be true. Evidence of an oral admission of the defendant should be viewed with caution. No person may be convicted of a criminal offense unless there is some proof of each element of the crime independent of any admission made by him outside of this trial. The identity of the person who is alleged to have committed a crime is not an element of the crime, nor is the degree of the crime. Such identity or degree of the crime may be established by an admission. Witness Ron Shipp testified to a statement alleged to have been made by the defendant concerning dreams. You must first determine whether such statement was made by the defendant. If you find the statement was not made by the defendant, you shall disregard the statement. If you find that the statement referred to subconscious thoughts while asleep, you are to disregard the statement. If you find that the statement referred to an expression of a desire or expectation, you may give to such statement the weight to which you feel it is entitled. Evidence of oral statements by a defendant should be viewed with caution. A defendant in a criminal action is presumed to be innocent until the contrary is proved, and in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the prosecution the burden of proving him guilty beyond a reasonable doubt. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction of the truth of the charge. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was the perpetrator of any such charged crimes. The defendant is not required to prove himself innocent or to prove that any other person committed the crimes charged. In the crimes charged in counts 1 and 2, there must exist a union or joint operation of act or conduct and a certain specific intent or mental state in the mind of the perpetrator. Unless such specific intent and or mental state exists, the crime to which they relate is not committed. The crime of murder in the second degree requires the specific intent to kill, known as express malice. The crime of murder in the first degree requires the specific intent to kill, known as express malice, and the mental state of premeditation and deliberation. These terms are more fully defined later in these instructions. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crimes charged in counts 1 and 2, or the crime of second-degree murder, which is a lesser crime, unless the proved circumstances are not only 1, consistent with the theory that the defendant had the required specific intent or mental state, but 2, cannot be reconciled with any other rational conclusion. Also, if the evidence as to any such specific intent or mental state is susceptible of 2 reasonable interpretations, one of which points to the existence of the specific intent or mental state, and the other to the absence of the specific intent or mental state, you must adopt that interpretation which points to the absence of the specific intent or mental state. If, on the other hand, one interpretation of the evidence as to such specific intent or mental state appears to you to be reasonable, and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If, after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. The defendant is accused in counts 1 and 2 of having committed the crime of murder, a violation of Penal Code Section 187. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Section 187 of the California Penal Code. In order to prove such crime, each of the following elements must be proved. 1, a human being was killed. 2, the killing was unlawful. And 3, the killing was done with malice aforethought. Express malice is defined as when there is manifested an intention unlawfully to kill a human being. The mental state, when it is shown that a killing resulted from the intentional doing of an act with express malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of considerable time. It only means that the required mental state must precede rather than follow the act. All killing, which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought, is murder of the first degree. The word willful, as used in this instruction, means intentional. The word deliberate means formed or arrived at or determined upon as a result of careful thought and weighing of the considerations for and against the proposed course of action. The word premeditated means considered beforehand. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not under a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it include an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing as murder of the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he decides to and does kill. Murder of the second degree is the unlawful killing of a human being with malice aforethought, where there is manifested an intention unlawfully to kill a human being, but the evidence is insufficient to establish deliberation and premeditation. Murder is classified into 2 degrees, and if you should find the defendant guilty of murder, you must determine and state in your verdict whether you find the murder to be of the first or second degree. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such a murder was murder of the first or of the second degree, you must give the defendant the benefit of the doubt and return a verdict fixing the murder as the second degree. Before you may return a verdict in this case, you must also agree unanimously, not only as to whether the defendant is guilty or not guilty, but also if you should find him guilty of an unlawful killing, you must agree unanimously as to whether he is guilty of murder of the first degree or murder of the second degree. If you find the defendant in this case guilty of murder of the first degree, you must then determine the following special circumstance, whether the following special circumstance is true or not true. The defendant has, in this case, been convicted of at least 1 crime of murder of the first degree and 1 or more crimes of murder in the first or second degree. The prosecution has the burden of proving the truth of a special circumstance. If you have a reasonable doubt as to whether a special circumstance is true, you must find it to be not true. In order to find a special circumstance alleged in this case to be true or untrue, you must agree unanimously. You will state your special finding as to whether this special circumstance is or is not true on the form that will be supplied to you. To find the special circumstance referred to in these instructions as multiple murder convictions is true, it must be proved that the defendant has in this case been convicted of at least 1 crime of murder in the first degree and 1 or more crimes of murder in the first or second degree. You are not permitted to find a special circumstance alleged in this case to be true based upon circumstantial evidence unless the proved circumstance is not only 1, consistent with the theory that a special circumstance is true, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the truth of a special circumstance must be proved beyond a reasonable doubt. In other words, before an inference essential to establish a special circumstance may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence is susceptible of 2 reasonable interpretations, one of which points to the truth of a special circumstance and the other to its untruth, you must adopt that interpretation which points to its untruth and reject the interpretation which points to its truth. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Each count charges a distinct crime. You must decide each count separately. The defendant may be found guilty or not guilty of either or both of the crimes charged. Your finding as to each count must be stated in a separate verdict form. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the crime charged, you may nevertheless convict him of any lesser crime if you are convinced beyond a reasonable doubt that the defendant is guilty of such a lesser crime. The crime of second-degree murder is a lesser to that of first-degree murder. Thus, you are to determine whether the defendant is guilty or not guilty of first-degree murder as charged in counts 1 and 2 or of any lesser crime. In doing so, you have discretion to choose the order in which you evaluate each crime and consider the evidence pertaining to it. You may find it productive to consider and reach tentative conclusion on all charges and lesser crimes before reaching any final verdicts.
You know, not working while you're at work is the same as stealing. And if you're going to start stealing, Kelly, you're going to find yourself in front of Judge Ito. You're heading down this dangerous path of crime and destruction. Watching OJ Simpson while you're at work. I'm disappointed in you.
However, the court cannot accept a guilty verdict on a lesser crime unless you have unanimously found the defendant not guilty of the greater crime. It is alleged in counts 1 and 2 that in the commission of the crime charged, the defendant personally used a deadly or dangerous weapon. If you find such defendant guilty of the crime thus charged, or a lesser included crime, you must determine whether or not such defendant personally used a deadly or dangerous weapon in the commission of such crime. A deadly or dangerous weapon means any weapon, instrument, or object that is capable of being used to inflict great bodily injury or death. The term used a deadly or dangerous weapon as used in this instruction means to display such weapon in an intentionally menacing manner or intentionally to strike or hit a human being with it. The prosecution has the burden of proving the truth of this allegation. If you have a reasonable doubt that it is true, you must find it to be not true. You will include a special finding of that question in your verdict using a form that will be supplied to you for that purpose. The purpose of the court's instructions is to provide you with the applicable law so that you may arrive at a just and lawful verdict. Whether some instructions apply will depend upon what you find to be the facts. Disregard any instruction which applies to facts determined by you not to exist. Do not conclude that because an instruction has been given that the court is expressing any opinion as to the facts of this case. All right, ladies and gentlemen, this concludes the instructions that I am going to give to you prior to the arguments of the attorneys. And as I indicated to you, we will stand in recess until Tuesday morning, September the 26th, to begin at 9 o'clock with the arguments of the attorneys. It's an interesting date because if you'll recollect, those of you who came to us in the first batch of jury selection, we actually started jury selection on September the 26th, 1994, and I see some people recollect that date. All right, at this point, you must remember all my admonitions to you. Do not discuss this case amongst yourselves. Do not form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to this case. All right, as far as the jury is concerned, we will stand in recess. I'm sorry.
Yo, of course there's a sidebar. Of course there's a sidebar. Yo, what the heck? Josh, you're right. What in the world just happened? Those were jury instructions? Thought he was going to talk about a stapled piece of paper and Furman not talking and OJ not talking and like what the heck just happened here? I feel like gypped. I paid a year of my life for this. Now you're going to gyp me? Thank you. Thank you very much. I appreciate that.
All right, ladies and gentlemen, the attorneys brought to my attention that I misread two of these instructions to you, so I'm going to reread them to you in their correct form. And they will be brief. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law, or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works or persons for additional information. You must not discuss this case with any other person except a fellow juror, and you must not discuss the case with a fellow juror until the case is submitted to you for your decision, and only when all 12 jurors are present in the jury room. One additional that I misread to you. With the exception of Nurse Thano-Paradas, evidence that on some former occasion a witness made a statement or statements that were inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on such former occasion. Evidence of the Thano-Paradas videotape statement, People's Exhibit 615, which may include statements that were consistent or inconsistent with his former testimony presented by the reading of the transcript of his former testimony given before both the grand jury and at the preliminary hearing, may be considered by you solely for the purpose of testing the credibility of Mr. Paradas' former testimony. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, such testimony is inconsistent with a prior statement or statements by him or her describing that event. All right, ladies and gentlemen, that concludes the reading of the preliminary instructions to you. After the attorneys finish their arguments, I do have some concluding instructions to you that are very brief. Remember my admonitions to you. Excuse me, please have a pleasant weekend.
Mistrial.
And we'll see you back here
Jury
on
instructions
Tuesday morning
cause
at 9 o'clock.
mistrial.
All right? We'll stand in recess.
Okay, now is the time, though, where mistrials really happen, when the jury is deliberating.
Your Honor, I'm also, first of all, I'm not most qualified to argue some of the boards because, as you may recall, I wasn't even here for the early portion of the trial when some of those matters came to the forefront. What I would suggest we do, since we were also told by the prosecutor.
What the absolute, what is going on? What are you arguing? The jury is in the room deliberating. Or is the jury asking for the boards? I thought, if I remember correctly, which I probably don't, I thought I heard that the jury only asked for like 3 pages of transcripts and none of the video or anything, right? I don't remember. It's fine. Why is he arguing? Who knows? Maybe the jury wants some of those boards. Maybe they want to play with the magnets.
Execution. They have a whole series of slides that were specially prepared for summation that are not in evidence already, and we have to review those as well before the summation begins. What I would ask is for the court's indulgence to give Mr. Shapiro and Mr. Cochran just 5 minutes to look at the that timeline board and the so-called abuse board, which they could do very, very quickly, and at the same time we could look at the slides.
That's why we started at 8 o'clock this morning, Counsel.
I know, and we were here on that, Your Honor. There were some technical glitches, but one of the things we expected to see at 8 o'clock this morning also was a slideshow. We've yet to have that pre-screened for us. So I'm simply asking that we have that done, and while we're doing that...
We're going to take up the boards first, Counsel.
All right.
All right, first one, evidence from the Bronco.
All right. Well, the problem we have with the boards, which are referred to as evidence from the Bronco, evidence at Rockingham, and evidence at Bundy, allegedly connecting Mr. Simpson to those three scenes, is that the court made a very explicit ruling early on in this case that the people cannot use the term match to refer to draw a connection or nexus between hair and fiber evidence and individuals. That you, in fact, had to instruct Ms. Clark repeatedly when she violated that rule to refrain from using the word match and stick to consistent with.
So the bottom line of your objection is that you object to the wording on the board regarding the hair and the fiber.
That's correct. Not regarding the blood, because the court drew the distinction there, but regarding the hair and fiber.
Right.
That although they're allowed to argue, they're not allowed to misstate the facts. And you set very strong parameters as to what the facts were with regard to hair and fiber.
All right, and that pertains to the evidence from Bundy, the evidence at Rockingham, and evidence from the Bronco boards, all
That's
three
right.
boards.
There was another board, which was a timeline board, and just from my initial review, and again, I would need the help of Mr. Cochran and Mr. Shapiro on this, is that there was a suggestion that Cato heard 3 knocks between 10:51 and 10:52, whereas his testimony, both on direct and cross, is 10:40 to 10:45, and there is no testimony of 10:51 to 10:52 in the record, and they have no business asserting facts on a board which don't exist in the record. So at least as to that statement of fact in the board, we would object to that and ask that it be changed. I think also you should bear in mind, Your Honor, that I believe that the prosecution has little cards and has the technical ability to make substitutions and changes depending on your rulings this morning, because they indicated that as to another time they were going to make a change and put a card on it. But again, I would like my co-counsel to just have just a 2-minute opportunity to quickly look at that board as well.
Love.
There's a lot
Have
of
a
different
good day
times
at
on
work.
it, and I'll be the first to admit that I don't have that kind of expert familiarity with every time suggested on there, and we would just like to be able to check it.
All right, any response to the objections regarding the boards? Ms. Clark, good morning.
Yes, Your Honor. I mean, if it even needs a response. I plan to argue, as the court is aware, that Mr. Diedrich can testify to what he saw through a microscope, and that can only be deemed consistent. But when we consider all of the evidence in the case, we know that it is his hair. And this is argument. That's the reasonable inference to be drawn. At this point, I should not be confined to saying it's only consistent, because I'm not just talking about Mr. Diedrich's opinion or conclusion based solely on the microscopic comparison. I'll make that very clear to the jury. There's not going to be any doubt in anybody's mind, and I'm not going to be saying Mr. Diedrich said it was a match. I'm not going to say that either. Mr. Diedrich said it was consistent. That's all he could say. That's all he knew. But when we look at all of the evidence, we know it's his hair. That's entirely permissible, in fact, mandatory argument in a case like this. So I don't think the court needs to hear that much more from me on that. With respect to the timeline, this is the problem with having lawyers argue that haven't been here. On the timeline thing, Cato said that he heard the thumps, and 2 to 3 minutes later he walked out of his room. Alan Park said that he was on the phone with his boss and hung up within 30 seconds of that, of seeing Cato and the defendant out in the yard. Cato on the side yard, the defendant in the driveway. We have his cell phone records that indicate that that phone call was completed at 10:55 something. It's on the board, Your Honor, in any case. So I time it by that. We have a very, very accurate way of determining when Cato went out to the side yard and when he heard the thumps based on that. Is there any
Okay,
questions?
that's it.
Those
We're
are the two
done.
objections to the boards.
All right. Looks like, so we're on the 26th of September right now, which has a lot of parts, because once they're done blabbering, which it looks like they're going to be done blabbering in about 40 more minutes tomorrow, they start closing statements. It looks like tomorrow, halfway through, a little before halfway through our live stream, they're going to start closing statements. Unfortunately, remember, there's no stream Sunday morning because I need those notifications. But So you're going to start the closing statement Saturday morning, not Sunday, and then Monday, Tuesday, Wednesday, Thursday, Friday. All right, I'm not going to go any further than that. We're still only on September 28th on Friday. There's a lot of parts. There's a lot of videos left. They're not all 2 hours, but the closing statements, as you probably would expect, are long. They're very long. But there's multiple people. So like Marcia goes up, and then Dearden goes up, Johnnie goes up, Sheck goes up, Johnnie goes up again, Dearden goes up again, Marcia goes up again. So, oh, it's hot in here. Oh my gosh. I'm dying right now. All right. I did put out an OJ Simpson short of when he spoke in court. It's not doing well. I guess no one cares. That's what I get. That's what I get. But it's fine. It's fine. We care. We were excited. We saw OJ Simpson speak at his murder trial. Together we did. Came out of nowhere. I had no idea. I had no idea about a whole bunch of stuff in this trial. I mean, I had no idea any of this was going to happen. But we are going to soon get to the part where if the glove don't fit, you must acquit. And it's going to mean something to us because we know everything about how gloves are stitched now. Thanks for coming out, guys. I appreciate it. I'll see you all again really, really soon. Have a great Friday. Be careful for the storm coming up. I'll see you again tomorrow. Bye.